Welcome to Judgement Justice. This is our first video, and henceforth, every week we'll be bringing videos to you on famous landmark judgments covering a variety of subjects. For today's topic, we will discuss about IPR landmark judgment. In today's generation, the prominent property is our intellectual property, which no one can steal from us. Intellectual property rights has proved itself to be invaluable in the socio-economic fields. It has gained popularity in the recent past and it motivates people to create and innovate. Whenever we come across Trademark Act 1999, the most popular Yahoo versus Akash Arora case pops up in our head. This landmark judgment is the first case relating cyber squatting in India. Cyber squatting literally means when someone copies a well-known company's domain name and tries to resell it in the intention of making profit. So in today's case, the plaintiff is Yahoo, which is a global internet media under the domain name yahoo.com. Yahoo.com applied for registration of trademark in India and the application was still pending because the defendant Akash Arora had already started providing similar services under the name yahoo.india. In the present case, the plaintiff sues for passing off the services and goods while using the identical name of the plaintiff's trademark Yahoo. The plaintiff prayed to the court for permanent injunction to prevent the defendant from continuing the usage of the domain name. In this case, court mainly framed three issues. First, whether an action for passing off could be maintained against services rendered. The second, whether a domain name is protected under the Trademark Act and Merchandise Act. Third, whether the use of the disclaimer by the defendant will eliminate the problem. So the defendant said in his defense that the action of passing off is only applicable on goods and not on services by the virtue of Section 2 of Subsection 5, Section 27, Section 29 and Section 30 of the Act. The Delhi High Court examined the issue and rejected the defense by saying that passing off action could be maintained against the services as well as services rendered could be recognized for the action of passing off. The Delhi High Court relied upon the main landmark judgment, Monetary Overseas versus Monetary Industry Limited. This judgment is given by the bench of Chief Justice of India, Ramesh Lahoti. In this judgment, Delhi High Court says that when a defendant does business under the same name or close name under which the plaintiff is trading and the name has already acquired goodwill and reputation in the large public, it is likely to mislead that the defendant's business is the business of the plaintiff or branch or a department in the plaintiff's business. Delhi High Court held that the domain name serves same kind of functions as a trademark and hence it has to be given same kind of protection. For this statement, High Court took reference from the famous US case USA Car Service International versus MCG. The court examined each and every issue and came to a conclusion that Yahoo.com had good reputation in the market, while the name adopted by the defendant was misleading the public and causing damage to the reputation of the plaintiff. In consequences, the court granted a permanent injunction in the favor of the plaintiff under the Rule 1 and 2 of Order 39 of CPC 1908. Hope you enjoyed our video. If you have any further queries about this case or any other case, please do drop a mail on justicejudgment30@gmail.com. We'll get back as soon as possible. If you liked this video, please like. If you have any suggestions for us, please do drop a comment and subscribe to our channel.